Hey, good morning, everyone. We'll call this meeting of the TRPA Legal Committee to order. The date is Wednesday, June 25th, 2025. The time is 8:30 a.m. First item on the agenda is the roll call to determine a quorum. Catherine?
Martinez, here. Mr. Keycapper,
Here.
Ms. Loomer, Ms. Williamson, and Ms. Aldine.
Here.
Vice Chair, we have a quorum.
Thank you. We'll now go over the remote and in-person meeting rules for the day. For the members of the public who are joining us remotely, to observe the meeting, go to trpa.gov under the calendar header. Click on Governing Board Hybrid Meeting for June 25th, 2025. There you will find a link to the public webinar hosted on Zoom. To address committee members directly with your comments, raise your hand in Zoom by clicking Raise Hand at the bottom of your screen at the appropriate agenda item. With your hand raised, you will be unmuted by TRP staff and have 3 minutes to address the committee. If you have used the dial-in number to join us by telephone, you can dial *9 to raise your hand and be unmuted. To remote committee members, and that would be you, Ben. If you wish to speak, please also raise your hand in Zoom. You will find the hand icon on the bottom of your screen. Remote committee members may not use the chat box to make any comments or have sidebar conversations. Please, everyone, remember to mute your mic unless speaking to cut down on background noise. Finally, I would like to ask that all remote members turn on their cameras if they are able to do so. Members of the public in the audience who have joined us in person, please raise your hand at the appropriate time for public comment, and you will be called on to the front to speak. First item on our agenda is public comment. For items on the agenda, any member of the public wishing to address the committee on an agenda item may do so at this time. If any members of the public wish to address the committee on any item on the agenda, please raise your hand now, either in person or by clicking the raise hand button at the bottom of your Zoom screen, or by dialing *9 on your phone, and you'll be called on and unmuted by a TRPA staff member. And let the record show that Ms. Loomer has joined us. Thank you, Catherine.
If any member of the public would like to make a comment, please click the raise hand button at the bottom of your screen. Madam Chair, there are no hands raised to comment.
Okay, then we will close public comment and move on to our next item, which is approval of the agenda. Graham, are there any changes to the agenda?
No change.
Other than we will not be having a closed session. Okay. Then we'll deem the agenda approved as amended. Next item are the minutes from the previous meeting. We're now on agenda item number 3, approval of the minutes. We have a draft set of minutes from May 28th, 2025 on page 9 of your packet. Does any member of the committee wish to make a change? Okay, and amazingly enough, I don't either. Good job. I will entertain a motion to approve the minutes as presented.
Move approval.
Thank you. All those in favor say aye.
Aye.
Aye. Any opposed? Ben?
Aye.
Thank you. And the motion passes. Next item on the agenda is item number 4, discussion and possible recommendation for the approval of resolution of enforcement action, MH Tahoe Residence LLC, Mark Tanner Construction and Grateful Gardens, unauthorized vegetation and tree removal in the shore zone at 9898 Lake Street in Placer County, California. Assessor's parcel number 090-321-006. TRPA file number CODE 2025-0019. Information on this item can be found on 105 of your packet. Graham or Steve?
Thanks. Steve Sweet, Co-Compliance Program Manager. This is resolution of enforcement action of MH Tahoe Residence LLC, Mark Tanner Construction and Grateful Garden Landscaping, collectively referred to as the settling parties. We did make one change in the staff or in the settlement, the new settlement agreement, where we changed Grateful Garden, the name to Grateful Garden Landscaping. So this violation involves unauthorized removal of vegetation located in the shoreline of Lake Tahoe. The violations occurred on the MH Tahoe residence property located at 9898 Lake Street, Kings Beach, adjacent to Speedboat Beach. Here's an overview of the location of the property, and then the next slide is a close-up of the area of disturbance that we'll be talking about. And you can see just to the right of the residence is the Speedboat Beach entrance. That small little walkway there. A short description of the violation. In July 2024, TRPA staff inspected a complaint at the MH Tahoe property resident for unauthorized vegetation removal along the shoreline of Lake Tahoe. During that inspection, TRPA staff discovered trees, large areas of willows, and other shore zone vegetation was cut to the ground without any TRPA authorization, causing disturbance to sensitive shore zone along the edge of the water. And we also discovered that holes were drilled in the boulders in the shore zone to install temporary fencing to prevent people from entering the MH Tahoe property. And I'll go over a few pictures here. The one on the left, is the main area of disturbance is over there just below the residence, where you can see the black fence. This was all put in after the fact, after the violation to control the erosion, because we were having some erosion go directly into the lake at that point. So they've stabilized this. And then over here on the right, see just more areas of kind of large willows cut in the shore zone vegetation. This is right there on the water next to their pier. The next picture, or the next slide, please. Again, more larger, some small trees cut. The center picture is, you can see a small tree next to the rock, a little stump there. There was some small trees around around this rock outcrop out there on the point that were cut, some like little trees, but have been growing for a long time. So those are sometimes trees we just can't replace in certain areas like this.
And that was deemed to be for view enhancement.
Well,
Do we know?
not necessarily for view enhancement. I think there was, you can hear from the contractor, but I think there was some mistakes made by what was supposed to be cut. And
Okay.
so it could have possibly been, some view enhancement. As you see on the picture on the right, you have some limbing done that was probably like borderline what we would allow out there. And so they were just doing way too much work out there without any authorization. Let's go to the next slide. And then again, we have some trees, small trees cut out on the point. Just another picture, you can see some of the branches and things over there on the left from when the work was done. And then again, some of the small trees that you just, to me, you can't replace some of those things growing in the rocks like that. Okay, the next slide. All right, and after further investigation and discussion with MH Tahoe representatives, we determined that the removal of all the shore zone trees and vegetation and disturbance to the shore zone was done without any authorization, in violation of 12 different code sections. I'm not going to go through them, but they were involving shore zone vegetation removal, tree removal, disturbance and discharge in the shore zone, and scenic requirements, and failure to install BMPs. And then, so the next slide, the settling parties, they've all taken responsibility for the unauthorized activities, and we've agreed to a settlement. Where staff's recommending that the governing board approve the proposed settlement agreement, and where the parties pay a penalty of $85,000 and restore the area pursuant to a TRPA approved restoration plan, which we have. The majority of the plan has been approved already. We're just changing a few items in it. Some of the species they couldn't find, so they want to change a few things like that.
Well, there are a few things already underway, right? Like the turbidity
the
screen.
stabilization is there. That's what they did originally, but so we
Okay.
watched it over the last year, kind of monitor, see what we needed additionally. And the permit that was approved here a couple months ago for some of the upland work included the landscaping work from the shore zone up. And so this restoration was for everything below that.
Okay. Is there a representative for the settlement party?
I
morning.
think I can sign on behalf
Hi,
of
Nick.
the proper term we'll want to use for those folks. Addressing the violation, just to touch on a few points. This was really an unfortunate situation. I think you asked, looking at some past violations and, previous shore zone vegetation removal. To your point, generally speaking, I would say that is almost universally done for scenic purposes. However, that wasn't the case here. In all honesty, as you know, I know it's hard to, kind of imagine, but where those trees are, we're actually not in the view angle of the house. And so the underlying willows also, because the way the house was developed, it was, a historical house where it's a one-story kind of built up. So actually your view corridor was above all the willows as they existed. And so really how this manifested was, it was a fire defensible space project, kind of advancing forward. The underbrush, kind of around the site, like many sites, was just really overgrown. And so, it was kind of a loss of communication kind of down from the team all the way down to the individual performing the work. And, they just kind of got ahead of themselves. But there wasn't, kind of those traditional things in which it was done for scenic purposes or anything like that. And, I think really appreciated working with staff through this process to, one, do the stabilization plan immediately after the violation was kind of provided to us. So that took place really quickly. And then working with staff, to see how the bed was going to grow over the year. Because the thought was that the willows and a lot of things would start to re-germinate, start to somewhat take care of themselves. And then to Steve's point, what did we need to do to add to that to augment what was removed? And so some of those pieces are still being sorted out, but really just wanted to provide a little bit more of that context. I see Mark Tanner, the properties contractor. I don't know, Mark, if you want to add anything, but wanted to be here in person to kind of provide that context and just explain, how this happened and be available for any questions.
Yes, thanks.
Okay.
Thanks, Nick. I can be available for any questions.
Did you have a statement to make, Mr. Tanner?
No additional statement.
Okay, thank you. So I guess my question is, I don't know, Mr. Tanner, if you're new to the basin, did you not know that a TRPA permit would be required for these activities?
No, I do know that a TRPA permit would be required for certain activities.
Okay, well, it's always best to inquire if you're uncertain about what falls under the jurisdiction of the agency, just to avoid, these complications, just for future reference.
Understood. Unfortunately, the subcontractor that performed the work, as Nick Exline stated, got more, for lack of better words, aggressive and went further than was previously discussed. And we did not have proper supervision because we felt that he understood and had it handled. And in a day, more was done than it should have been.
Okay, all right. Thank you for that. I appreciate it. Any comments or questions by members of the committee? I just had a quick question, Steve. Under violation number 8, it says TRPA has a discretion to elevate this project due to the impact on recreation. What was the impact on recreation? I'm just curious.
The impact to recreation was like maybe the adjacency to the speedboat beach.
Oh,
And,
okay,
yeah.
okay, great. And relocation.
It's a really popular area right there.
Mhm.
And so I don't think it actually benefited the property owner to do that because it opened up the property to all of Speedboat Beach too.
Right.
For people coming around and they hang out on that point.
So the fencing that was installed that was attached to some of the boulders that were drilled,
Yes,
was that a mitigation measure or was that to prevent people from wandering onto the site when construction was underway?
we felt that was to prevent people. I mean, it appeared like it was more to prevent people from going on the property, because of that line of, the public beach there and this
Okay.
property.
As opposed to a safety measure.
Yeah, there wasn't. Yeah, I didn't understand because there wasn't any construction going
Yeah.
on, so it didn't make sense to put up.
Yeah, no, I just to kind of get into that fencing and that point, and I think Steve's correct in that. I think actually the removal to those adjacent users of the public space probably benefited the rec opportunity due to improved access. But in reality, to the fence in question, it was actually something that took place kind of, with best of intentions. And so, as the kind of the violation was brought forth, I was communicating with Mark Tanner and his team, and my thought was, okay, we got to get temporary BMPs and we got to get this stabilized stat, right? Like this is an immediate action. And so in an effort to kind of really get ahead of things and kind of, demonstrate that we wanted to solve this solution, the installation of those fences in question was an attempt to do BMP temporary stabilization, kind of the filter fabric fencing. Similarly, I guess in alignment with the removal of vegetation, would have been better to have more kind of discussion with TRPA staff prior to that, but it was done with the best of intent to stabilize the site. And just as, if you're not familiar with that area, it's pretty accessible. And so that the minimal filter fabric fence was not a barricade, more so looking to show a good effort to TRPA that we were looking to mitigate the problem.
Okay, thank you, Nick. And the relocation of boulders, I'm assuming that they weren't using heavy equipment, they were just using manpower to relocate boulders.
There was no heavy equipment used at all, and there was no relocation of boulders. That's an error in the report.
Would you like to address that, Steve?
Yeah, I don't think there was that's probably an error.
It's item 12 on page 111.
I think that's just a,
Is it
what
just a
that
code
is,
reference?
it is a code reference, and so it's, it's inclusive, it's.
Yeah, it's just,
Okay.
it's rough.
Okay, because it's italicized. All right, okay, all right.
We had a chance to discuss with Steve some of those nuances, like from the code reference to the actions and violations and so forth. So felt good with the interactions with Steve as well.
Yeah,
Great.
we didn't change any of the language or remove any of the code sections, but we did reduce the penalty over the last month from the last month's settlement agreement.
Which was?
It was 105,000.
Okay.
Originally, we reduced it to 85,000 because we worked through some differences in the two violations and felt that it was an appropriate amount.
Good. Right, then I will go ahead and entertain a motion to recommend approval of the settlement agreement as shown in attachment A.
So moved.
We have a motion. Any comments on the question? All those in favor say aye.
Aye.
Any opposed? Motion carries. Okay, Nick, thank you so much for being here. Next item on the agenda is agenda item number 5. Discussion and possible recommendation for approval of resolution of enforcement action, Joseph Portali, unauthorized stream environment zone vegetation removal and material damage to trees at 704 Lakeview Avenue, South Lake Tahoe, California, assessor parcel number 026023-006. For information on this item, please go to page 113 of your packet.
All right. Again, Steve Sweet, co-compliance program manager. This violation involves unauthorized removal of vegetation located in the stream environment zone. The violations occurred on the California state property located at 704 Lakeview Avenue in South Lake Tahoe, adjacent to the Portali residence. Can you go to this is an overview of the area. This is kind of at the end of the El Tahoe neighborhood. And then a close up. And here you can see the Portali residence, just outside of, adjacent to the state of California property highlighted in yellow. And the red arrow is kind of the line of sight from his residence out to the lake. And the area of disturbance that we'll be discussing highlighted in the orange there, circled in the orange circle. A quick description of the violation. In November 2024, the California Tahoe Conservancy, referred to as the CTC, investigated some unauthorized vegetation removal that had taken place on the California state property adjacent to the Portali residence. CTC discovered that Portali had removed multiple willow bushes and limbs from several trees for view enhancement from his residence to Lake Tahoe, and they notified TRPA of the violations. After further After further investigation and discussion with Mr. Pertally, TRPA staff determined that 2 willow clusters were removed and 8 trees had limbs removed in the lower 1/3 of the tree's height, causing some material damage to these trees. So let's go, can you go to the next slide? This is the picture of the willow clusters. And you can see Mr. Pertally's residence just back to the right, on the right side of the picture, the white residence there. And then the next slide, turning around, looking the other way, out towards the lake. And this is the area where the trees were limbed up. And I have, next slide, please. A few pictures of the limbing of the trees there for his view enhancement. And I think that, okay. And then so the vegetation removal for view enhancement is not an allowed reason for tree removal. And it's a violation of TRPA code section 30.5.2. In this case, it was and did, the removal of all vegetation from the stream environment zone is required to get a permit. Mr. Pertally has taken full responsibility for the unauthorized work and has agreed to a settlement. Staff is recommending that the governing board approve the proposed settlement agreement where Pertally pays a penalty of $10,000 and pays the CTC $6,000 for the cleanup costs on the property for the unauthorized work performed.
How was this discovered? Were you contacted by an adjacent homeowner?
By the
CTC.
CTC, yes.
CTC. Okay, well, it looks pretty straightforward. Is there a representative of the settlement party?
Mr. Pertally.
Mr. Pertally's online. Good morning.
Hi, guys. Nice to meet you, Steve, face to face. Yeah. I mean, I did it, so I don't really have, I did trim the trees. I just wanted to be honest and let you guys know I did it, so I'm okay with the settlement. I mean, it's a hard one to pay, but it's my responsibility, so.
Okay, well, I appreciate that. And when in doubt in the future, just pick up the phone and give TRPA a call.
Okay, I will.
Okay, all right, thank you. And again, Steve, you want to reference the change in the settlement agreement?
Yes, there was 2 changes in the settlement agreement, we changed,
Address.
in item number 3 of the settlement agreement, we reduced the doubling of the penalty to 32,000 from 52,000. That was a mistake. And then we also added the address and the location of the violation into the settlement agreement.
Has the settling party signed an amended copy?
They have.
Okay, great.
Yes.
Thank you. Any questions by members of the committee? Okay, Ben, any questions?
Nope, no questions.
Okay, thank you. All right, I'll entertain a motion. Approval. All right, we have a motion to approve. Any comments on the question? This time we'll do it by roll call. If you want me to go back and we can do a roll call on the previous legislation. Need to follow protocol here. Catherine, will you take the roll?
Ms. Fastinos?
Yes.
Mr. Keycapper?
Yes.
Ms. Loomer?
Yes.
Ms. Aldine?
Yes.
Madam Chair, the motion passes.
All right, thank you very much. Right, next item on the agenda is discussion and possible recommendation of amendments to the rules of procedure, Article 11.6, appeal of removals. Brad?
Right, got the slides.
And this item can be found on 119 of your packet.
All right, good morning, Legal Committee. Yeah, this is a very short presentation today for a proposed change to our rules of procedure following the court's decision in Harash versus TRPA. So let's see, it's a little trouble. I'm looking at my slides. Let me see if we can just get that moved. Let's see. Thanks, Cal. So again, we've talked about this case. This is a change to the board's voting procedure for appeals of staff issued permits. Again, we're talking about staff issued permits and when those decisions are appealed. And again, it's necessary for consistency with this recent court decision. Where in the Harash appeal, the court, in its opinion, said that the governing board's vote fell short of the compact's requirements. We'll take a look at that at the next slide. Thanks. Okay, so the existing rule says that if the board determines to hear an appeal, and again, we're talking about staff issued permits. This rule 11.6.2 is staff issued permits. It may take action to modify or revoke the approval by the same affirmative vote as would have been required to approve the matter before the board. So that's a 5-9 vote. So it would be a 5-9 vote required. That's double super majority to modify or revoke the approval, basically pull the permit back. And failure to take such action by that super majority vote shall be deemed a denial of the appeal. So again, looking at those bullets down below, the existing rule frames the appeal as a vote to revoke or modify, not approve. And the Harash decision said that this structure does not satisfy the compact's voting requirements. So it's a very targeted amendment to this rule. We're focusing on just this aspect, really the actual holding of the Harash decision. And the way that we would change the rule is to basically say, we did add some language at the beginning to reference the fact that a permit issued by the executive director or other delegee. That's because we have memorandums of agreement with local jurisdictions where there are other delegees that make approvals. And so the rewording would be to strike, modify, or revoke, and to change the word, add the word affirm the approval, and just some sort of syntax on this next part have been to be, and then basically the failure to take such action, failure to basically approve by the 5-9 shall be deemed a grant of the appeal, which means, you know, if you grant the appeal, you're not issuing that permit, not affirming the permit. So again, the bullets down the bottom, it requires the board to affirmatively vote on the permit using the 5-9 vote. That's what the court's decision requires. And then absent that 5-9, the appeal is granted, meaning the permit does not issue. And I've said it a bunch of times, but again, we're just talking about appeals of staff issued permits. The rules regarding appeals of decisions not to issue a permit our existing rules are still fine. They're not affected by that Harash decision. I think, is there one more slide, Ken?
No.
Nope, that's it. I guess the next one's the motion. Or do we not?
The motions are after.
Oh, okay. Gotcha. Thank you.
So I guess I have a question, Graham. Will we be placing all delegated project approvals on the consent calendar going forward as suggested by the court?
No, that is not, we do not interpret the Harash decision as that being a holding of their case. That was something they said in dicta, which is just like
Recommendation.
yeah, like, well, you could do that, but that's not the holding of the case. And yeah, so we don't need to do that.
Okay, all right. Any member of the committee have any questions?
No, I actually appreciate this section because it's going to clarify the way that we vote on it.
I know, it's always been very awkward,
So,
very odd.
yes.
Yes, Alex.
If I'm just wondering if we could narrow it, instead of saying granting the appeal, could it be a revocation of the permit? And just,
Well, it's more, appreciate the suggestion. I think, you go back to language. I think we want to be saying that failure to take such action shall be deemed a revocation
of the underlying permit.
Yeah, I would leave it. I think we want to be as narrow as possible with the language. And even though we use the word affirm the approval, I think what we want to be saying is that when there's an appeal, the board needs to issue the permit. The board needs to be the one that's doing the verb, that's acting. And so I think revoking, I want to be like as faithful to this court decision as possible so that yeah.
Okay, is there a scenario where the appeal could be broader than, could have something more in it than just the permit? Does that make sense? Like, could there be other things included in the appeal where if we're granting the appeal, that could capture more than just revoking the permit? I read it as broader, but like, if you see this as actually more narrow,
I
I'm
mean,
open to that.
it's hard, I struggle with these, honestly, I mean, we could take it back. I think I would recommend, so the legal team and we put thought into, as you imagine, into getting these words right, and it's hard for me to do this in the meetings.
Yeah,
and
yeah,
I wouldn't recommend to make changes like that in the meeting like this. And part of the reason for doing this today is because we're coming back with the Johannesson permit next month. And the rule changes, they go into effect at the next board meeting.
right.
So it's important that we get this in today. Now you can make a rule change if the board unanimously agrees to make it effective immediately. But I'm just hesitant to do something here that then has like kind of unintended
Yeah, yeah.
consequence. So what I think this is sound. We could take it under advisement and see if there's a reason to
Yeah.
tweak that further. That would be my suggestion. I know it's.
Yeah, I had a similar comment. I mean, granting an appeal, it almost sounds like you're granting them the right to appeal, as opposed to affirming that there are grounds to reverse the permit. So my suggested change, and I know you don't want to do this on the fly, and that's fine, but we may want to re-examine it, would be failure to take action shall be deemed a grant of the appeal and a reversal of the approval. I mean, in other words, what is the ultimate outcome? It's the reversal of the approval, right, if the appeal is granted. And we're not just saying you have the right to appeal, we're saying that there are some consequences to the action being taken, and that would be the revocation of or the reversal of the approval.
I mean, I think that's implied. I think
Okay.
that's, and I like to be as like narrow, when we make changes to these things, I like to be as less words as possible. Like, I just like to be as narrow as possible and very exacting. And so, I mean, I think it's very much implied that, failure to take such action shall be deemed a granted appeal. When I'm appealing a staff issued permit, I'm saying I don't want that permit to stand. And so that's the appeal. It's like, please, don't issue this permit.
But to Alex's point, it could be that the appeal is narrower than that. In other words, there's one aspect of the appeal. It's not the project that they want to reverse, but there's something in the approval or the permit itself that is inaccurate or erroneous. And so I feel, this is just and I'm not a lawyer, but I feel the more specificity, the better, because then it's less likely to be misinterpreted. But that's it.
Yeah,
Well, I mean, I think you can also, I'm speculating, you can also potentially grant an appeal in part. And that would depend on, during the actual hearing, kind of amending whatever the motion is, that like we grant this part of the appeal, but we deny. I mean, that can sort of be addressed depending on the circumstances.
Okay, well, this is not like amending the compact. I mean,
Yeah.
I can't come back and amend it at a future date if it doesn't fulfill our needs.
I appreciate that, Jack. Thanks. Yeah, that was a good addition. I mean, a lot of times if it's like, hey, somebody's appealing a very narrow aspect of a permit, I mean, it might not come to the board because we might just handle that at the staff level and saying, oh, there's a mistake here or whatever. But if there is some kind of I'm trying to think, like somebody appeals, let's say, a project of a house.
Mitigation measure.
Yeah, or let's say, because I got it in my mind, like,
Okay.
we issue a permit for a large house addition or something like that, and it includes a removal of a tree. And somebody nearby, a neighbor, appeals the permit, because they don't like the tree, right? They don't like the tree removal, but they're fine with everything else. I think I would still say that when that appeal comes forward, it's now the board's responsibility to issue that approval, which includes everything, includes the tree, includes all aspects. And so the board then is reviewing that application and can say, can weigh in on that tree as part of the project or not. And the board can say, we will approve as it's applied for, or we will approve without that tree because the appellants, but they're still gonna need to vote the super majority, the 5-9, to issue that. And, you know, if they fail to get the votes, if the permittee does not get the 5 votes from the board, again, with or without that modification to the project, they won't have the permit. The permit won't issue. And in a sense, that's deemed a grant of the appeal. And we could probably take out that whole last sentence, failure to take such action shall be due. It's not really super important to this whole piece. The important piece is that you need the 5-9 votes to issue the permit. And when there's an appeal, it becomes the board's responsibility to do that.
And it's written as a positive as opposed to a negative.
Correct.
Which is something that everybody
Yeah.
has just really had trouble grasping.
Yeah.
Okay, all right.
So again, we can go back, like after this, I'll review our transcript here. And try to, you know, get more, if you want to say any more about that to look at, but
Yeah, no, I think I made my point, so yeah.
okay,
Yeah.
yeah, we'll take a look.
That, and I'm to say the prior language, the existing language did have that broader perspective. So it's like, it's not like
Yeah.
you're changing,
Right,
you know, so.
it's just a reversal.
Exactly.
Yeah. Mhm.
Okay. Any more questions or comments? All right, then I will entertain a motion.
Motion to recommend the governing board approve the required findings as described in attachment A, including a finding of no significant effect for adoption of the proposed amendment to the rules of procedure. And I understand we have to take these one at a time.
Yes, yes, there have a motion. Catherine, would you please call the roll?
Zimmer,
Yes.
Ms. Faustinos,
Yes.
Mr. Keycapper,
Yes.
Ms. Aldine.
Yes.
Madam Chair, that motion passes.
Okay, motion number 2.
Motion to recommend the governing board adopt resolution 2025 to amend rule 11.6 of the rules of procedure as shown in attachment B.
Okay, Catherine.
Mr. Keycapper,
Yes.
Ms. Loomer,
Yes.
Ms. Faustinos.
Yes.
Ms. Aldine.
Yes.
Madam Chair, that motion also passes.
Okay, thank you so much. All right, we have, as previously noted, we have no closed session today, so we will move on to committee comments. Any member of the committee have any comments?
Yeah.
Okay, Ben, any comments?
I have no comments. Thank you.
Okay, thank you. Our final matter of business is our general public interest comment period. Any member of the public wishing to address the legal committee on any item listed or not listed on the agenda may do so at this time. Individuals or groups who have already commented on items listed on the agenda are not permitted to comment on the same topic. The legal committee is prohibited from law from taking immediate action on issues raised by the public during this public comment period. Finally, comments must relate to matters within the jurisdiction of the agency. Any member of the public wishing to speak at this time, please raise your hand now, either in person or by clicking the raise hand at the bottom of your Zoom screen or by dialing *9 on your phone, and you will be called on and unmuted by a TRPA staff member. All right, we don't have anyone in the audience, obviously, other than members of staff. So anyone online, Catherine?
Yes, we have one hand raised online. Alan Miller, please unmute to make your comment.
Hello,
Hello.
Mr. Moore? Yes, we can hear you.
Alan Miller, professional engineer here to highlight written comments you posted online. I call the sad truth about TRPA. I augment my comments under the circumstances and recommend striking Rule 11.6.1 in its entirety based on my written comments. At least give the aggrieved the right to an appeal. The decision in Harash clearly rebukes TRPA policies and legal theories set against the unambiguous terms of the compact. TRPA is a scofflaw, losing on every important legal point. Taking the narrowest view possible of the outcome, TRPA here demonstrates its collective intent to move past Harash's findings and continue its ongoing violations of the compact. I detailed the violations in the petition I filed publicly with TRPA on March 25th, and the Harash decision greatly vindicates and bolsters my petition and Miller versus TRPA lawsuit in most major respects. But it's a hollow victory because everyone loses. The lawsuit doesn't really matter because my comments include a graph of Lake Tahoe summer clarity showing the steep decline since TRPA's beginning. Despite TRPA and partners, more pollutants continue to go in than can be absorbed without further decline. Meeting the water board's total maximum daily load regulation has proven insufficient to prevent further degradation, with no response to the TMDL more than a dozen years on in the graph. Only continued steady decline. There will be no restoration of Lake Tahoe clarity in any event. The graph makes that obvious. TRPA has sealed Lake Tahoe's fate because TRPA has never followed the compact. The graph shows the restoration opportunity has been lost by 45 years of TRPA being married to its illegally existing processes, a long love affair with its streamlined staff approvals, failures to study impacts, limits on public participation, bullying and posturing with only a pretense of compliance with the compact and regulations, appeals in its kangaroo court, papering over its failures with local and regional propaganda, and its lame defense of its corrupt practices in court as here. Also, it would take true leadership from within to change TRPA leadership, not in evidence. That is the sad story of TRPA writ large in Harash. It's nothing new, and the public deserves to know how Lake Tahoe was degraded impermissibly despite the compact. My comments, Harash, and the petition tell the story with more details. The people have no real say under TRPA rules. TRPA has failed Lake Tahoe and refuses to change, nor will the legislatures intervene. The future of Lake Tahoe water quality is continued decline. I'd prefer it was otherwise, and that's the sad truth as I see it.
Thank you for your comments. Anyone else interested in commenting, Catherine?
No, there are no other hands.
Okay, then we'll go ahead and close public comment. Is there a motion to adjourn?
So moved.
Okay, all right, we have a motion. All those in favor say aye.
Aye.
Aye. Any opposed? All right,